I thou. Congress cannot plan. Case.
How much time do we have left?
352.
Referring to an institution or people as it produces them to an object can be controlled, to solve the evidence, destroys mutuality and dialogue, assume something that can be object and manipulated, only viewing something as a thou or their actual persons who can change this biological determination or to solve the evidence as I thou is critical to a process of understanding the people as people or institutions as people. Their argument that the Supreme Court is only institution is exactly our link that we can read them as manipulative and non-existent human beings to solve. This is only breaking this relationship or returning to them who they actually are can solve the metaphysical violence of the one as he talks about. This turns all their biopolitics arguments talks about viewing people as an object or as rational that we can control the same. When they do that through the Supreme Court, they solve the entirety of this case. The risk of a link, they say there's not a link as an institution versus an object. Against our argument, you view people as non-existing institutions instead of the actual people that comprise them. This is a reason why you should revert to the Supreme Court instead of based on its this they can't solve because there's all this language going on in the status quo. This is nonsense. This is referring to what the affirmative does. Their biopolitics arguments. The reason why in individual instances of this form of domination is bad. They say permutation. You both show links to the argument can overturn the residual arguments which you referred to. The members of the Supreme Court is an it instead of a thou. If they advocate this as a severance argument, they should lose because that destroys our counterplan ground. They should be held accountable to whether in the plaintiffs they can't say solve for the F. It's a theoretical question. They come first. Their own biopolitics arguments. The reason why we should discover these theoretical principles of first. If we win that your F is worse and we should not refer to when is the reason why we should lose the counterplan solves the case. They say the PICS argument. They say it's not real world. Listen, their textuality arguments on the Supreme Court advance talks about the importance of understanding what the Supreme Court says, which means all of these real world arguments are irrelevant there. So they say they can't figure out advance. It's the reason why they should put what's in their plan their plan takes and picks are key to focus debate laws into discussion, increasing education, especially necessary on this topic when there's difference between court jurisdiction, how it phrases words, and two is key to take topic explosion. They can read an infinite number of add-ons. With some reason why we need to check this back to AF solvency bias justified solvency literature is better for the term means picks to overcome the enactment society defend the whole entire plan to make explicit choices to defend exactly what the read the plan text and in competition literature check abuse. There's no benefits literature for absurd examples. We have specific definitions, specific literature on why you should not use a phrase it, and this excludes all counterplans since they often include part of the plan like USFG actions. Counterplans key negative strategy since its users harms are biased in the affirmative directions and all liberal-based topics, and they have side by justified their friend the debate proceedings of infinite prep and potential for abuses irrelevant. Don't punch justice to another judge's job in another debate, and not a voting against your rejected theory. Not the team counterplans should just go away, and it leads to more and this should be held accountable to the plan text. This is not a sort of floating tick, but it's something that they specifically use. They say that they solve this valuelessness. Listen, this card talks about the importance of what the plan would do. They still refer to the institution or to solve the evidence. This is a prerequisite for how we relate to people. They say plan opens a new space. Even if your new space is important, they can't plan solve. That's the question of how you refer to people in the world. They say that these debates are inevitable. Listen, just because these debates are inevitable isn't a reason why you should vote affirmative. The inevitability debate means you should vote negative. You endorse a better project. Counterplan at the top solves the entirety of the case. To cross-examine is damning. They don't have one card in the context of abortion, which is the reason why you should err towards negative extent of tribe evidence. That we solve the entirety. We solve the case with tribe says we can go past the Supreme Court decision to most qualified in the terms of abortion, saying the Supreme Court would not rule this decision back or to West evidence as deciding net benefits is basing this on the constitutional legal principle justifies juridical modes of thought and flows. The Supreme Court allows a Supreme Court to bypass prayers to politics. West evidence is the only way to change conceptions of motherhood and how we relate to laws to congressional action. They say you can't solve the act because it's on the book. Listen, all of their evidence of the one he talks about the importance of having some sort of change to the way women access abortion. And it's the same terms cannot insurance abortion right to precisely the same terms as the affirmative and bolster public support, congressional protection, shifts debate, and guarantees public acceptance of a broader right. Balkan, the five solution is not to give a broad to defend the democratic political party. The Democrats promote the federal choice of acts that would codify able to break the abortion political branch to take responsibility and take all the blame of the hate rather than take court, take political aid, maybe down the legitimacy, brown out the civil rights, the person worse than the freedom of choice act passes. It will produce the constitutional settlement in favor of women's liberty. And three, reconceptualization of liberal sexuality. All the gay evidence on case proves they put the cart before them for horse law reflects social understandings of our sexuality, not the other way around. Injecting the plan into law without prior social change through democratic process inherently limits the scope of the effort, locks us into place all other forms of sexual normalization, and perversely validates current regimes. Only Congress can navigate the broad national law custom and belief necessary to alter social understanding of gender, guaranteeing expansive recognition of reproductive rights at West. And we have evidence to prove this bill from Congress is the only way to reverse the tide. Court rulings never transcend the limits of scope of abortion. West and five should respond to incompetently motherhood and citizenship, rather change teachers and so that even the mothers continue the line serve the working mother and inconsistent citizenship. We should should insist on child-friendly workplace, must insist on current income support, tax rebates, all of these reasons why we're leaving accountability mother and sister. What's wrong is that the last attempt to pay for constitutionalism, social organization by giving a gloss over voluntariness is someone brutal expression way out of a board decision. Understanding the Congress should be commented. It's only to take in people obfuscation by facile suggestion that the court can probably be avoided by simple expedients to giving women a right to abortion. And they say the counterpoint is they say that our Rob West Evans doesn't have an impact. We should explain that above, and we should explain that evidence above. They say that courts aren't key cross-examination proof. This card does not say anything. It just talks about why this card just says Congress hasn't done it before. The courts haven't done your plan before. It's relevant. They say the courts are about the cross-examination. Says this talks about bureaucratic action. Does not mention the Congress. Congress is not bureaucratic. It's talking about agency. And the card is it's not bureaucratic or West Evans is democratic political progress. It's more important. The permutation still links to both the DA and our West Evans. Second of all, the card does not say anything. It says Congress is critical and does not give a warrant on whether permutation is good. The cross-examination proves this, and only Congress alone can solve court action blocks effective reframing and church on many fights over the laws. West in 2005 might be open to dangers of trying to gain full congressional expression, constitutional ramifications, subordination of women to the traditional family, legitimate social concerns with the expedience of providing legal means supporting of the courts taking different ground. It might have a signal that Congress' central role play restricted some impulse to take the moment we had done so we would have the Congress actually engage in work of legislating every end of the court would least periodically cut to strike back every time Congress attempts to do so. We must take the lead. Courts only get in the way. Congress must be free established or interpretive legislation on its own Balkan. And five, although the courts have been based on critics works working with the large structural problems such as inequality, but striking down the abortion law pathetically and aggregate attempt by emphasis of Congress to support the amendment equally through the courts were starting Congress breast able to pass legislation protection security rights and citizenship. They say the courts won't validate the cross-examination proof. This card is talking about Scalia and an abortion tribe. He was a little bit more qualified immediately after the case decision says it actually grants Congress broad interpretation. They're just not allowed to overrule the decision itself. They say conditionality. They say conditionality is bad. First, two counterplans are bad. Counter-interpretation negative only gets one counterplan and one critique. That was just your critique of a specific alternative which increases the Afghan. If we only get a counterplan, we can't test any of the F assumptions. They possibly distort dialogue and critical questioning and not infinitely regressive. The number of possible counterplans is limited by the literature, and the net benefits of most real world. The opportunity cost of the F is the next best alternative. Multiple counterplans below the negative to determine the best alternative. People who argue cases before the court have to defend against a variety of arguments from a variety of justices, and it's their fault for writing their plan wrong. They should be punished for not thinking about the plan through and search for the best policy option justifies comparing multiple policies. Church will find the best one, which is the educational process of debate too. And Christian thinking multiple options force both things to make good tactical choices. Debate is the best when it's hardest and it's key to next flex without conditionality. Then I can't recount points of critique same debate, which is critical to attack the plan from multiple angles. It's key that equalize side by side, multiple factors make the hardly half. The F is infinite. Preference chooses to focus on debate. B cheat get the 2 error advantage. F gets to make choices and frame the debate less B and perms. Take explosive because they only take 2 seconds to make it hard and make they are restrictable with counterplans. And it's key to check that your chip shots without conditionality arguments like no negative and get artificially inflated into voting issues and status quo should always be a logical policy option. Policymakers should be forced to defend the status quo worse and no contradictions. We don't look worse to any of our other positions, and all negative arguments are conditional. They're forced to reason to reject the F and no time skew counterplans are harder to answer than the A to T and time to use on a voting issue. Otherwise, yeah, that's so bad. And potential for abuse is relevant. Don't punish us. That's another. Judge job another round. And dispositionality does not judge its arbitrary standards, does not solve our offense and collapses. And to conditionality. So. Sending evidence is no larger impact by biopolitics. They say biopolitics is a loss. They can see there's no reverse causality why the plan would trade off with things like funding, abortion clinics, and the status quo, which are necessarily regulates in the government. And evidence that there's been no regulation, there's minimal regulation in the status quo, majority of women can access the abortion services, which means it should not be based on constitutional questions but how we actually access women. In the case of distinction revolves primarily are 2 daily evidences that actually increases the agency of woman. Their argument that it's more important what we do for the woman takes up any offense they can make on any of our counterplans, because this card says it's not the legal questioning or the words we use. They make the argument is the actual restriction. So if they say the Supreme Court needs to overrule decisions, you should spike these as bad. You should ignore these arguments because all other arguments talk about how you can access to women. Then they change their mind saying the language the court used. If that's true, the Casey decision used the language of agency, which should have all started off with all the cases and the variety arguments based on legal institutions and shrines. The coding of justice and the law arguments explains that the liberal initial subject that abortion assumes already based on discrimination. Extended abortion discourse trades off of pregnancy or facile evidence as least as social abortion and conservatives use an attempt to increase eugenics. You also consider progressive politics arguments that you splinter the ability for the left to do things like increasing health care. So Gabriel evidence to answer this. It wasn't an essential argument which increases health care, which on evidence assumes is more important.
Okay. The card that you're on the counterplan by Balkan says that the court should protect basic abortion rights. That's the line from the card, actually. So I don't see how this is a reason why the
Sure,
Congress...
it does. Basic abortion rights like
They haven't overruled the Roe decision. The card says what the Congress should do is establish further forms of right, i.e. overruling
Congress's
cases.
duty to enforce the 14th Amendment independent of the courts.
Sure.
West argues that Congress is the only body to pass legislation that protects women's equality and secures their equal citizenship.
Yeah,
that
that's
doesn't
pretty
actually
good.
talk about having to pass abortion laws. It seems to indicate
It
that
says-
abortion regulations...
It says the court should not overrule Roe, and then what Congress should do is that you read the last part of the law, card that literally just said Congress ought expand abortion rights.
No, it says Congress ought to expand women's equality and secure their equal citizenship.
Which is
Do you have
what
an internal link or a reason why?
Your plan says you
Okay,
allow
that's
equal
fine.
citizenship
The
of
West
women. Our
evidence that you
counterplan
read
does
above
that.
talks about legitimizing subordination.
Yeah.
It doesn't actually indicate that Congress's abortion should be acted on by the Congress. Is your answer to the question, right?
The multiple pieces of West evidence above prove Congress is deciding the question. That card is a disaster to the court action. We don't say Congress alone is critical in that card because we read it as a disaster to the court.
Okay. Your I thou criticism indicates how do you solve for the types of metaphysical violence? You seem to just
We're not,
assert
it's
this conclusion that
silly,
you solve.
just like y'all don't claim to solve for all biopolitics. It would
Right,
be
but
very
how does it
odd
reject
for us to say we solve all metaphysical violence. We say the instance that the affirmative uses is bad. In your plan text, you shouldn't support it. You should vote negative instead.
But what does voting negative achieve?
It doesn't do your case and doesn't lead to metaphysical violence. It's like a textual alternative that if the judge's decision should be getting rid of metaphysical violence, they can easily vote negative to endorse a plan without using the language of it.
Okay, what is the warrant for why the public would be more accepting of the counterclaim?
It's not imposed by 9 members of the Supreme Court, which closes off dialogue and is viewed as judicial fiat.
What card is that? Did you get that?
A bunch of West cards that.
No, but I thought you read a card.
Oh, I probably did.
And why is the court perceived as more legitimate because it's 9 members versus the bureaucratic system of the
It's
congressional?
not a bureaucratic system. Bureaucracy assumes agencies aren't voted for. We should get this straight again. Our argument is that Congress are perceived as more legitimate because they're voted for. People deciding to have them elected. The Supreme Court would rule by fiat, telling people how they do and don't view on abortion, which our evidence explains was also
How do you
massive
change the conceptions
adverse.
of motherhood with the counterclaim?
Sure, our West evidence is moving things to the Congress and having women's rights be a focal point in Congress means we can start altering things like how healthcare works, how child services work when people go to workplaces.
Why?
Our evidence explains that Congress is the only institution within women's rights can change those things. The courts obviously can't. Can I have a second to prep? I forgot to answer the question. It's the last